This is part 49 as far as our lecture series is concerned, and in this part we try to understand provisions as to bail and bonds. In order to understand the provisions regarding bail and bonds, the time first of all for us to understand as to the distinction or classification of the offences under two different heads: bailable offences and non-bailable offences. If you just have glance at subclause A of section 2 of the Criminal Procedure Code, which defines bailable offence, it says bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the timing in force, and non-bailable offence means any other offence. So this is as far as section 2A, which defines bailable offence, is concerned. But by reading this provision, you understand only one thing, and that is, in order to know whether the offence is bailable or non-bailable, this is a time for you to refer to the fifth vertical column of the first schedule of the Criminal Procedure Code, where you come across classification of the offences. So, by reading the definition, it has got only reference to fifth vertical column of the first schedule of the Criminal Procedure Code, and in order to know whether the offence is bailable or non-bailable, you have to refer to fifth vertical column to find out the offence, with which we have dealt to a certain extent at the time of discussing the importance of the first schedule of the Criminal Procedure Code during course of our series of lectures. Along with this, now, in order to know the provisions as to bail and bonds, you have to start reading right from section 436 up to section 450 up to section 450 of the Criminal Procedure Code, with which we shall be dealing as far as this part of the lecture is concerned. And then, to understand this, I hope you remember I had told you in the past that this is also the time for you to refer to from form number 45 up to form number 56 for the purpose of understanding the provisions in the real sense of the term, to have absolute clarity regarding understanding of this topic. So there are various forms to which you have to refer to, so that your understanding when you deal right from section 436 up to section 450 of the Criminal Procedure Code becomes very clear. Now, if you start now, what is the distinction between bailable and non-bailable offences, and then if you read section 436, which tells you in what cases bail to be taken, and it says when any person other than a person accused of a non-bailable offence is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court and is prepared at any time while in custody of such officer or at any stage of the proceeding before such court to give bail, such person shall be released on bail. What does it mean? Bailable offences are those offences in which case person can claim bail as a matter of right, provided he is ready and willing to fulfill the terms and conditions as that are laid down by the provisions of the law. So this is bailable offence. Proviso to this section says, provided that such officer or court, if he or it thinks fit, may and shall in such a person is indigent and is unable to furnish surety, instead of taking bail from such person, discharge him on his executing a bond without sureties for his appearance as hereinafter provided. And explanation to the section says, where a person is unable to give bail within a week of the date of his arrest, it shall be sufficient ground for the officer or the court to presume that he is an indigent person for the purposes of this proviso. Provided further that nothing in this section shall be deemed to affect the provisions of subsection 3 of section 116 or section 446 capital A. Subclause 2 says, notwithstanding anything contained in subsection 1, where a person had failed to comply with the conditions of the bail bond as regards the time and place of attendance, the court may refuse to release him on bail when on subsequent occasion in the same case he appears before the court or is brought in custody, and any such refusal shall be without prejudice to the powers of the court to call upon any person bound by such bond to pay the penalty thereof under section 446 of the Criminal Procedure Code. So this is regarding bailable offence as dealt by the provisions of section 446 of where person can claim bail as a matter of right as far as section 436 is concerned. Now, if we start reading section 437, it says, when bail may be taken in case of non-bailable offences. And it says, when any person accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court other than the High Court or Court of Session, he may be released on bail. But so it is not shall, but he may be released on bail. In other words, non-bailable offences are that offences, or non-bailable offence is that offence in which person cannot claim bail as a matter of right, but he may or may not, that is at the discretion of the court of law. But then further part of the section says, but such person shall not be released. So there is no provision of releasing. The court has got no power. Such person shall not be so released if there appears reasonable grounds for believing with death
or imprisonment for life. 2. Such person shall not be so released if such offence is a cognizable offence and he had been previously convicted of an offence punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he had been previously convicted on 2 or more occasions of a cognizable offence punishable with imprisonment for 3 years or more, but not less than 7 years. So though the court has got discretion to release person if he is accused of an offence of which nature is non-bailable, but these are the exceptions where the court shall not release such person on a bail, provided that the court may direct a person referred to in clause 1 or clause 2 be released on bail if such person is under. So there are exceptions. 1, if such person is under 16 years or is a woman or is a sick or infirm person. Provided further that the court may also direct that a person referred to in clause 2 be released on bail if it is satisfied that it is just and proper to do so for any other special reason. Provided also that the mere fact that an accused person may be required for being identified by witnesses during investigation shall not be sufficient ground for refusing to grant bail if he is otherwise entitled to be released on bail and gives an undertaking that he shall comply with such directions as may be given by the court. Provided also that no person shall, if the offence alleged to have been committed by him is punishable with death, imprisonment for life, or imprisonment for 7 years or more, be released on bail by the court under this subsection without giving an opportunity of hearing to the public prosecutor. With this now, the other section to which I want to draw your attention at this point of time is section 167 of the Criminal Procedure Code. And if you read subclause 2 of the section along with the proviso,
Proviso says, provided that the magistrate may authorize the detention of the accused person otherwise than in the custody of police beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under this paragraph for a total period exceeding 1. 90 days where the investigation relates to an offence punishable with death, imprisonment for life or imprisonment for a term not less than 10 years. 60 days where the investigation relates to any other offence. And on the expiry of the said period of 90 days or 60 days as the case may be, the accused person shall be released on bail if he is prepared to and does furnish bail, and every person released on bail under this subsection shall be deemed to be released under the provisions of chapter 33 for the purposes of that chapter. So this is one more exception, that the court has got, even though the nature of the offence is non-bailable, court has got discretion. In other words, it is right of the person to get himself released on bail as far as this provision is concerned. With this now we come to as far as subclause 2 of section 437 of the Criminal Procedure Code is concerned. It says, if it appears to such officer or court at any stage of investigation, inquiry or trial as the case may be, that there are not reasonable grounds for believing that the accused has committed a non-bailable offence, but that there are sufficient grounds for further inquiry into his guilt, the accused shall, subject to the provisions of section 446 capital A, and pending such inquiry, be released on bail or at the discretion of such officer or the court on the execution by him of a bond without sureties for his appearance or hereinafter provided. Subclause 3 says, when a person accused or suspected of commission of an offence punishable with imprisonment which may extend to 7 years or more, or of an offence under chapter 6, chapter 16, chapter 17 of the Indian Penal Code, or abetment of or conspiracy or attempt to commit any such offence, is released on bail under subsection 1, the court shall impose the conditions that such person shall attend in accordance with the conditions of the bond executed under this chapter. B. That such person shall not commit an offence similar to the offence of which he is accused or suspected of the commission of which he is suspected. That such person shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer or tamper with the evidence, and may also impose in the interest of justice such other condition as it considers necessary. Clause 4 says, an officer or court releasing any person on bail under subsection 1 or subsection 2 shall record in writing or its reasons or special reasons for so doing. Subclause 5 says, any court which has released a person on bail under subsection 1 or subsection 2 may, if it considers it necessary so to do, direct that such person be arrested and commit him to custody. Subclause 6 says, if in any case triable by magistrate, the trial of the person accused of any non-bailable offence is not concluded within a period of 60 days from the first day fixed for taking evidence in the case, such person shall, if he is in custody during the whole of the said period, be released on bail to the satisfaction of the magistrate unless, for reasons to be recorded in writing, the magistrate otherwise directs. And 7th clause says, if at any time after the conclusion of the trial of a person accused of a non-bailable offence and before judgment is delivered, the court is of opinion that there are reasonable grounds for believing that the accused is not guilty of any such offence, it shall release the accused if he is in custody on the execution by him of a bond without sureties for his appearance to hear judgment delivered. So this is regarding, say, as far as section 437 is concerned. With this now, we have to deal with one more section, and that is section 436 capital A, which deals with maximum period for which an under trial prisoner can be detained. And it says, where a person has, during the period of investigation, inquiry or trial under this code of an offence under any law, not being an offence for which the punishment of death has been specified as one of the punishment under the law, undergone detention for a period exceeding up to 1/2 of the maximum period of imprisonment specified for that offence under that law, he shall be released by the court on his personal bond with or without sureties, provided that the court may, after hearing the public prosecutor and for reasons to be recorded by it in writing, order the continued detention of such person for a period longer than 1/2 of the said period, or release him on bail instead of the personal bond with or without sureties. Provided further that no such person shall in any case be detained during the period of investigation, inquiry or trial for more than the maximum period of imprisonment provided for the said offence under that law. Explanation says, in computing the period of detention under this section for granting bail, the period of detention passed due to delay in proceeding caused by the accused shall be excluded. With this now we come to one more section, and that is section 437 capital A, which says bail to require accused to appear before next appellate court. And it says, before conclusion of the trial and before disposal of an appeal, the court trying the offence of the appellate court, as the case may be, shall require the accused to execute bail bonds with sureties to appear before the higher court as and when, and such court issues notice in respect of any appeal or petition filed against the judgment of the respective court, and such bail bonds shall be in force for 6 months. Subclause 2 says, if such accused fails to appear, the bonds stand forfeited and the procedure under section 446 shall apply. So this is as to provision as far as the provisions regarding bail in case of bailable and non-bailable offences, for which we have taken into consideration 2 sections, namely section 436 and 437. Now one more term, the term which is nowhere used by any one of the sections of the Criminal Procedure Code, but which is used in day-to-day life and known to everybody, is what is known as an anticipatory bail. But to understand the provision, as we don't come across this term anywhere, neither defined nor used by any one of the provisions of the Criminal Procedure Code, you have to refer to only one section, and that is section 438. And what is the wording of the section? It says, direction for grant of bail to person apprehending arrest. And subclause 1 says, where any person has reason to believe that he may be arrested on the accusation of having committed a non-bailable offence, he may apply to High Court or to the Court of Session for a direction under this section that, in the event of such arrest, he shall be released on bail, and that the court may, after taking into consideration inter alia the following factors, namely 1. the nature and gravity of the accusation. 2. The antecedents of the applicant, including the fact as to whether he has previously undergone imprisonment on conviction by a court in respect of any cognizable offence. 3. The possibility of the applicant to flee from justice, and fourthly, where the accusation has been made with the object of injuring or humiliating the applicant by having him so arrested, either reject the application forthwith or issue an interim order for the grant of anticipatory bail, provided that where the High Court, or as the case may be, the Court of Session, has not passed any interim order under this subsection, or has rejected the application for grant of anticipatory bail, it shall be open to an officer in charge of a police station to arrest without warrant an applicant on the basis of the accusation apprehended in such application. Subclause 1 capital A says, where the court grants an interim order under subsection 1, it shall forthwith cause a notice being not less than 7 days notice, together with a copy of such order, to be served on public prosecutor and the superintendent of police, with a view to give the public prosecutor a reasonable opportunity of being heard when the application shall be finally heard by the court. Subclause 1 capital B says, the presence of the applicant seeking anticipatory bail shall be obligatory at the time of final hearing of the application and passing of final order by the court, if on an application made to it by the public prosecutor, the court considers such presence necessary in the interest of justice. Subclause 2 says, when the High Court or the Court of Session makes a direction under subsection 1, it may include such conditions in such a direction in the light of facts of the particular case as it may think fit, including a condition that the person shall make himself available for interrogation by a police officer as and when required. 2. A condition that the person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or any police officer. 3. A condition that the person shall not leave India without previous permission of the court. Fourthly, such other condition as may be imposed under subsection 3 of section 437 as if the bail were granted under that section. Subclause 3 says, if such person is thereafter arrested without warrant by an officer in charge of a police station on such accusation and is prepared either at the time of arrest or any time while in the custody of such officer to give bail, he shall be released on bail, and if a magistrate taking cognizance of such offence decides that a warrant should issue in the first instance against that person, he shall issue a bailable warrant in conformity with the directions of the court under subsection 1. This is regarding the person can make an application when he apprehends, and this application is what is known as anticipatory application for anticipatory bail. But mind well one thing, the provisions regarding bail come into operation only when the person is arrested. And what is arrest with which we have dealt? It is a confinement as per the conditions laid down by the law. There can be arrest with warrant, there can be arrest without warrant. So setting person free. So bail presupposes that the person is arrested, and it is setting person free from a legal custody subject to certain conditions which are required to be fulfilled. So in case of this anticipatory bail as it is known, mind well one thing, this provision will come into operation only when he is arrested, otherwise not. There is misunderstanding. that a person whose application is granted by the court of law as per section 438 is not arrested, which is not correct. He is arrested, and then because bail will come into operation only when he is arrested, otherwise not. So that is as far as section 438 of the Criminal Procedure Code is concerned. With this now, section 439, which deals with special powers of High Court or Court of Session regarding bail, and it says a High Court or Court of Session may direct A. that any person accused of an offence and in custody be released on bail, and if the offence is of the nature specified in subsection 3 of section 437, may impose any condition which it considers necessary for the purpose mentioned in that subsection. B. that any condition imposed by magistrate when releasing any person on bail to set aside or modified, provided that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offence which is triable exclusively by the Court of Session, or which, though not so triable, is punishable with imprisonment for life, give notice of the application for bail to the public prosecutor unless it is for reasons to be recorded in writing of the opinion that it is not practicable to give such notice. Subclause 2 says, High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and committed him to custody. So that is as far as section 439 is concerned. With this now, section 440 deals with amount of bond and reduction thereof, and it says the amount of every bond executed under this chapter shall be fixed with due regard to the circumstances of the case and shall not be excessive. Subclause 2 says the High Court or Court of Session may direct that the bail required by a police officer or magistrate be reduced. Subclause 441 says bond of accused and surety. Before any person is released on bail or released on his own bond, a bond for which a sum of money as the police officer or the court as the case may be thinks sufficient shall be executed by such person, and when he is released on bail by one or more sufficient sureties conditions that such person shall attend at the time and place mentioned in the bond, and shall continue so to attend until otherwise directed by the police officer or court as the case may be. Subclause 2 says where any condition is imposed for the release of any person on bail, the bond shall also contain that condition. Subclause 3 says if the case so requires, the bond shall also bind the person released on bail to appear when called upon at the High Court, Court of Session or other court to answer the charge. Subclause 4 says, for the purpose of determining whether the sureties are fit or sufficient, the court may accept affidavits in proof of the facts contained therein relating to the sufficiency or fitness of the sureties, or if it considers necessary, may either hold an inquiry itself or cause an inquiry to be made by a magistrate subordinate to the court as to such sufficiency or fitness. Declaration of sureties is dealt as far as section 441 capital A is concerned, which says every person standing surety to an accused person for his released on bail shall make a declaration before the court as to the number of persons to whom he has stood surety, including the accused, giving therein all the relevant particulars. Section 442 deals with a discharge from custody, and it says as soon as the bond has been executed, the person for whose appearance it has been executed shall be released, and then if he is in jail, the court admitting him to bail shall issue an order of release to the officer in charge of the jail and such officer on receipt of the order shall release him. Subclause 2 says, nothing in this section 436 or section 437 shall be deemed to require the release of any person liable to be detained for some matter other than that in respect of which the bond was executed. Section 443 deals with power to order sufficient bail when that first taken is insufficient, and it says, if through mistake, fraud or otherwise insufficient sureties have been accepted, or if they afterwards become insufficient, the court may issue a warrant of arrest directing that the person released on bail be brought before it, and may order him to find sufficient sureties on his failing so to do, may commit him to jail. Section 444 deals with discharge of sureties, and its subclause 1 says, all or any sureties for the attendance and appearance of a person released on bail may at any time apply to a magistrate to discharge the bond either wholly or so far as it relates to the applicants. Subclause 2 says, on such application being made, the magistrate shall issue him his warrant of arrest directing that the person so released be brought before him. Subclause 3 says, on the appearance of such person pursuant to the warrant or on his voluntarily surrender, the magistrate shall direct the bond to be discharged either wholly or so far as relates to the applicants, and shall call upon such a person to find other sufficient sureties, and if he fails to do so, may commit him to jail. Section 445 deals with deposit instead of recognizance. When any person is required by any court or officer to execute a bond with or without surety, such court or officer may, except in case of bond for good behavior, permit him to deposit a sum of money or government promissory notes to such amount as the court or officer may fix in lieu of executing such bond. 446 deals with procedure when bond has been forfeited, and it says, subclause 1 says, where a bond under this code is for appearance or for production of property before a court, and it is proved to the satisfaction of that court or of any court to which the case has subsequently been transferred that the bond has been forfeited, or where in respect of any other bond under this code it is proved to the satisfaction of the court by which the bond was taken, or of any court to which the case has subsequently been transferred, or of the court of any magistrate of the first class, that the bond has been forfeited, the court shall record the ground of such proof and may call upon any person bound by such bond to pay the penalty thereof, or to show cause why it should not be paid. The explanation to the section says, subclause 1 says, a condition in a bond for appearance or for production of property before a court shall be construed as including a condition for appearance, or as the case may be, for production of property before any court to which the case may subsequently be transferred. Subclause 2 says, if sufficient cause is not shown and the penalty is not paid, the court may proceed to recover the same as if such penalty were a fine imposed by it under this code, provided that where such penalty is not paid and cannot be recovered in the manner aforesaid, the person so bound as surety shall be liable by the order of the court ordering the recovery of the penalty to imprisonment in civil jail for a term which may extend to 6 months. Subclause 3 says, a court may after recording its reasons for doing so, remit any portion of the penalty mentioned and enforce payment in part only. Subclause 4 says, where a surety is bound dies before the bond is forfeited, his estate shall be discharged from all liability in respect of the bond. Subclause 5 says, where any person who has furnished security under section 106 or section 117 or section 360 is convicted of an offence, the commission of which constitutes a breach of the condition of his bond or of a bond executed in lieu of his bond under section 448, a certified copy of the judgment of the court by which he was convicted of such offence may be used as evidence in proceeding under this section against his surety or sureties, and if such certified copy is so used, the court shall presume that such offence was committed by him unless the contrary is proved. Section 446 capital A deals with cancellation of bond and bail bond, and it says, without prejudice to the provisions of section 446, where a bond under this code is for appearance of a person in a case and it is forfeited for breach of a condition, A, the bond executed by such person as well as the bond, if any, executed by one or more of sureties in that case shall stand cancelled, and B, thereafter no such person shall be released only on his own bond in that case, if the police officer or the court, as the case may be, for appearance before whom the bond was executed is satisfied that there was no sufficient cause for the failure of the person bound by the bond to comply with its conditions, provided that, subject to any other condition of this code, he may be released in that case upon the execution of a fresh personal bond for such sum of money and bond by one or more of such sureties as the police officer or the court, as the case may be, think sufficient. Section 447 deals with procedure in case of insolvency or death of surety or when a bond is forfeited, and it says, when any surety to a bond under this code becomes insolvent or dies, or when any bond is forfeited under the provisions of section 446, the court by whose order such bond was taken or a magistrate of the first class may order the person from whom such security was demanded to furnish fresh security in accordance with the directions of the original order, and if such security is not furnished, such court or magistrate may proceed as there had been a default in complying with such original order. Now, when section 448 deals with bond required from minor, and it says, when the person required by any court or officer to execute a bond is a minor, such court or officer may accept in lieu thereof a bond executed by a surety or sureties only. Section 449 deals with appeal from orders under section 446, and it says, all orders passed under section 446 shall be appealable. In the case of an order made by magistrate to the court of session, in the case of an order made by court of session to the court to which an appeal lies from an order made by such court. So this is as far as provision regarding appeal is concerned, as far as section 449 is concerned. And section 450 deals with power to direct levy of amount due on certain recognizances. The High Court or Court of Session may direct any magistrate to levy the amount due on a bond for appearance or attendance of such High Court or Court of Session. That is as far as section 450 is concerned. Now, During the course of understanding these provisions, you will find out, if you go through the decided case law, you come to know when the nature of the offence is bailable, the view that is taken by the Supreme Court is when person makes an application and is ready and willing to comply with the terms and conditions that are laid down, bail is a rule and jail is an exception. So it may be with respect to the offences as dealt by section 436 and 437. Whereas when person makes an application as per section 438, somewhere in the section as it is made, he makes an application for anticipatory bail. In that case, for example, though there cannot be bail in anticipation of an arrest, but this is only granting court passing an order in case the person is arrested. So the person is arrested, mind well, there cannot be bail in anticipation, and hence when person makes an application as per section 438 of the Criminal Procedure Code is concerned, this power, which is required to be exercised either by the High Court or the Court of Session, there are only two courts which are vested with this power, should be used by the Court of Law very sparingly, only under extraordinary circumstances as per the directions given by the Supreme Court in n number of cases. And what should be the result of the application? The result of the application should be jail is a rule and bail is an exception as far as the application as per section 438 of the Criminal Procedure Code is concerned. With rest of the part as far as Criminal Procedure Code is concerned, we will continue our discussion as far as next part of our series of lecture is concerned.